It's about making you believe that these people have the authority that they claim they do, when they have none. You have to give them every ounce of authority that they have.
Yeah, I had Suzanne Small, the Franchise Tax Board, actually tell me, without a hint of shame, that she's a lawyer, when the government orders you to do it, it's not threat, duress, and coercion. Really. She says, the law, this is what she says to me, Mark, the law doesn't recognize it as a threat, duress, and coercion. Really, can you, so let me ask you, I'll put you on the spot here. If somebody said to you the law doesn't recognize it as threat, duress, and coercion, what would you say to that?
Me? You're asking me now?
Yeah, I'll ask you. So someone said, yeah, how do you answer a statement like that? What do you, Ben, the law doesn't recognize it as threat, duress, and coercion.
I'm not exactly sure, Mark. I don't know.
Most people are just too stuck
Yeah.
on them being an authority. Well, the law. See, the law hypnotizes you and like, well, okay. But can you cite that? That's what I said. Can you cite that?
What do you mean by that?
Well, she's saying to me, Mark, the law doesn't recognize it as threat, duress, and coercion. Well, can you cite the law that says that?
Oh, I see. Right. Gotcha. Yeah. Yeah.
So when the BS comes out,
Yeah.
put the burden, keep the burden on them.
Oh, I see. Yeah, I got it. Yeah, I'm with you now. Yeah.
So if you keep the burden on them, so if they throw you, I had one lawyer say to me on the bench, Linda Scott, she says, I am prepared to rule as a matter of law. Objection, which law would that be? I am not going to discuss that with you.
Right.
If they have grounds, they'll give it to you.
Right.
And so it all, don't take the fictions, don't accept the fictions, and challenge. Don't accept what they say. I had, the common one was somebody will file a motion to dismiss, like in the parking traffic stop. And they said, well, the judge said this doesn't apply here. What do I do? Well, why would you accept that as an answer?
Right. So you could ask them, can you cite that? Could you say that?
Well, yeah, exactly. Can you cite me where the legal exception is for this particular court?
Right. Yeah.
And then if he doesn't give you anything, turnabout is always fair play. A lot of what I do, I have taken from them, and I use it against them. The one who makes the accusation bears the burden of proof.
Right.
This is an adversarial process. This was not like the old Inquisition where it was obviously they were there to kill you. It was just a matter of, well, how would you like to be killed today? Will we dismember you when we're done? So it was overtly criminal. They weren't fooling anybody that it was not about justice. But here they put on there it is about justice. So It's adversarial. So the adversary has the burden of proof.
Right.
And the one who's making the accusation should have some basis. Now, whether they want to admit that or not, I don't care, because I can get them to admit it.
Yeah, this is more so when it deals with the Crown. You never want to question the court's jurisdiction. You walk into their courtroom. Whether or not you're in chains or not is irrelevant. Maybe you should let them know that you're not there, willingly. When you then use the next argument, which is, I'm not challenging the court's jurisdiction. I'm challenging the jurisdiction or the authority of the Crown to bring me here. It's your adversary, not the judge. The Crown is your problem. The Crown has made false accusations against you that you are an agent of the Crown subject to statutes and regulations. That's your problem, not the judge. The court has all the authority in the world to hear the matter before the court. The problem is the Crown didn't have the authority to have you kicked in the teeth and dragged in there. And then you tell them why.
Wholeheartedly agree with you, but unless you're willing to back that up with action, I mean, you just...
There you go. Back it up with action. That is operation of law, is it not?
People will say, well, what's your method? What's your method? I don't accept the fictions and I ask questions. That's it. Well, fiction, I'm talking about like an abstraction, something that only exists in someone's head. And language is, at the same time, like they say in NLP, our greatest tool and also one of our worst weapons. Because unlike animals, we're capable of abstract thought.
Right.
Unfortunately, a lot of people engage in abstract thought, mostly lawyers and bureaucrats, politicians. They believe it's real. So when I talk about fiction, it's just something that's made up. It doesn't exist outside the head. And so when you don't buy into the fiction that you're a taxpayer, that you're legally obligated, or that you're within the United States, because that's a fiction also, or that you're within the realm, or whatever, or in the shire, or whatever they're calling it there, or the province. If you don't accept those fictions and you just look at them as people or the ground, and then you put the burden on them to prove it, what you're doing in a sense, in a very real sense what you're doing, and I explained this in workshops, you are forcing, and I don't like to use the word force, but you're making them actually think, and you're showing that the words in their head have no physical referent. Again, you didn't accept the fictions, and whatever they're putting forth, whatever they're spewing, the words, remember, it's words, all words in their head, If you just question them on it, it will come out. It is just in their head. All you're doing is you're looking at people as people and not accepting any of the fictions whatsoever, and just questioning them and bringing out that their words have no physical referent. They think they do. They act as if it's real. They act like you're a taxpayer, and you have to accept that from their point of view, but then meet them at that map of the world, and then just ask questions to bring out that it really doesn't refer to anything physical. And it doesn't have to be, someone claiming to be from the government. And one of the most effective things that I've seen is, oh, you've got a claim against me. Could you give me a factual timeline, and I'll cut you a check. I want to know where, when, why, and how. Just give me a factual timeline, write it out. If you want to do it on a penalty of perjury, that's great. And that's usually enough, because they're let me use an example. I don't have anything here. But if I say I can play guitar like Steve Vai, do you argue with me, or do you just hand me a guitar?
I think this is in a famous book that's supposed to be considered a rather ancient textbook called His Last Will and Testament. I know you by your actions. You can say all you want.
Yeah.
But I know you by your actions. Do you act it? Do you believe it? Are you going to back it up with action? Yeah, say anything you want. You can spout off about all sorts of horse shit, but when it comes right down to it, do you believe it, and are you going to back it up? It's my understanding the people of this land are the sovereign authority, and I'm one of the people of this land, and I got dragged in here against my will.
That's all I suggest that people do. Use a scientific method and just ask questions.
Right.
Don't form your hypothesis or anything, unless you've done some investigation and it's based on something. I can form a certain conclusion based on prior experience. But I don't necessarily do that when I'm talking with the agent. I want the facts to speak before the opinion. So I had this happen just the other day.
Yeah.
She said, the tax agent, she said, I walked her through the process. She had the authority to abate. The grounds to do an abatement was a lack of witnesses and evidence. And so she said, if you want me to abate, you're going to have to provide substantiation. I said, well, I've already done it, but I'll do it again. And so I don't just make an accusation. I have the facts to back it up. And I said, well, my substantiation is you told me you were authorized to do an abatement. You told me the grounds to justify an abatement would lack of witnesses and evidence. You told me there were no witnesses. You told me there was no evidence. You also told me you've never had any contact with the agents who may have done these assessments. That's my substantiation. Those are facts. That just happened. We can document that. So those are facts. See, that's something I think a lot of people do miss. We're absolutely certain, and I can prove beyond any doubt, beyond all doubt, no one's a taxpayer. It's very easy. But I got to have more than just my accusation or just my statement. So when I file with the IRS or I'm doing it with the IRS, I have my position that will be that there are no witnesses and evidence to show my client's a taxpayer and has taxable income. Well, what facts do I base that on? I had the phone call. I spoke to agent, let's say I spoke to Ms. Clemens on Wednesday, November 9th. I then spoke to Ms. Tabone, and I have badge numbers. So I've got my opinion, my statement, my thesis, let's say, and then I have my supporting facts. And that's the way we do it. So like I mentioned to someone today, I could be wrong. There may be witnesses. There may be evidence. So if I'm incorrect as to that, what does the IRS then have to do?
Produce them.
Yeah. And we stick to the facts because they have to produce them. All they have is their opinion. Well, Mark, you're wrong. I might be. But I've got these phone calls. I've got you. Now, if you think I'm wrong, are you able to testify? Are you qualified? and so we keep sticking on the same point. I could be wrong. I've been known to be wrong. I accept it. Do you have any witnesses with personal first-hand knowledge? And we're right back on that.
Right.
When you do stick to the facts and you don't take legal opinions, such as, like, my opinion, my position is based on what the witnesses from the IRS have told me. I mean, this is IRS agents telling me this, and lawyers. That's not me. It's not my opinion. They're telling me there's no witness. When I do it that way, that there's no witnesses and evidence on my client's taxpayer, that is completely different than saying I'm not a taxpayer within the meaning of statute. I mean, one is fact, one is opinion, and they're completely different. If you go on opinion, then they can point out, well, Mark, the courts have ruled, and they can use stare decisis to settle an issue of law. But you cannot use stare decisis. Well, you may not use stare decisis to settle an issue of fact because every case is fact specific. That's another reason why you can do that. So that, I don't care what the courts have said. So if I'm dealing with you, Ben, do you have a case of res judicata? And you're like, no, what the? See, res judicata is when a court and a jury has made a determination on the facts.
Oh, right. Okay.
Then it's over. But only for that year. So if it's taxes, it's only for 2005. If they did it has no application for 2009 because, hey, things change. So that's another reason why it's so important to stick to the facts. Because they don't have that option of saying, well, yeah, in the case of, Carrington versus Entick, 1769, they did rule. It doesn't matter.
Right. Right, because it doesn't apply to the facts that you've got in that case. Right.
Exactly. When you get a summary judgment in a court, it is because there are no issues of fact to be determined by a jury or trier of fact. There's just issues of law for the court to decide. So there's no trial.
Right.
So they want to get you locked into a situation where there's no trial. I just take their statements and use it against them. If I say an agent's incompetent, it's because they told me.
Right. Oh, I see. So we want the dispute of facts. We don't want the facts to be settled in summary judgment. We want to win on the dispute of facts. Have I got that right?
Yes. What you're doing, if you have a dispute of the facts, you're taking a huge monkey wrench and jamming it in the works and not allowing them to have summary judgment, which is basically judgment without a trial, which means they don't have to give you any discovery, nothing, which they're supposed to do.
Well, that's where the remedy comes in, and that's why I say never do any of this stuff until you're prepared. And prepared means you've corrected everything in advance.
Because if you go into court and you don't know what you're talking about, they'll eat you alive. They just start screaming and you lose your train of thought. And I don't understand what's going on. I have a few questions. Because the English system, Ben, just like over here, where they adopted it from, you're entitled to be informed so that you can adequately defend yourself.